Companies have never tracked their employees more closely than they are doing right now. And that trend is really only going to continue. You have a manager calling an employee hours after their shift end. There's other countries that have passed laws to try to combat the right to basically turn your phone off when you leave for the day. That hasn't happened here, and that's not going to happen here. When you're running trillion-dollar businesses, a case, even if it's bringing millions, it's a liability of millions of dollars. It's just a decimal point. On the defense side, when you're representing companies, who exactly your client is can change, what their priorities are can change. And so you're dealing with a lot of layers, a lot of moving pieces, a lot of shifting of priorities. On the plaintiff side, there's no shift of priorities. That sort of messiness, that kind of human experience instantly drew me to labor and employment. I think it's by far and away the most human of civil litigation.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a litigator who knows the opposition's playbook because he helped write it. After years defending the nation's largest employers in high-stakes disputes, he made a bold pivot to cross the V. Now a partner at Sommers Schwartz, he uses his insider knowledge of corporate defense strategy to fight for employees in wage and hour, discrimination, and retaliation cases. It's my pleasure to welcome Ethan Goemann to the podcast. Welcome, Ethan, and thank you for being here.
Thanks, Aniket. It's great to be here, and then thanks for the lovely introduction.
I appreciate it. Thank you for making the time. Ethan, as you know, I love to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
I'm going to go with a cringe joke. So I'm a father of a couple young children, and my 2-year-old has been recently dropping her nap. So that's become a bigger fight. In the afternoons, is trying to get her down. There was one day where I was trying to get her down for a nap, had gotten her pretty close, got up and left the room. And sure enough, 2 seconds later, I hear the little pitter patter footsteps. She comes out of the door. And I was so frustrated, I turned around and charged her with resisting arrest.
Oh, man, yeah. Did you read her Miranda rights as well? And did he ask for a lawyer?
I guess it wasn't completely lawful.
That is pretty funny. I think of every attorney who makes the time to be on the show as a superhero, and every superhero has an origin story, and I would love to hear yours.
So both my parents are lawyers. So the legal life has always been part of my life. And I think I grew up with a sense for and a respect for the power of the law and the legal systems in our country. Both my parents are more in the public service sphere, which wasn't something I was quite as interested in. But that led me to law school. At Duke Law, I had some fantastic professors, particularly 2 labor and employment professors, Professor Bowling and Professor McCauley, were just fantastic professors and really kind of turned me on for the first time to labor and employment work. So after law school, I clerked for a year for a U.S. District Court judge in Charlotte, Judge Mullen. And after that, I went to Womble Dickinson, which is a large law firm in North Carolina. I was hired there to be both a general civil litigator and a labor and employment litigator. My first case in general civil lit was this contract dispute between 2 businesses, and I was bored out of my mind. It was one of those things where I read a complaint 5 times through and none of the information had stuck at all. It just was not for me. And then my first labor and employment case was something totally different. It was in this blue collar industry. It had a manager who had become a big fan of the show RuPaul's Drag Race. And he starts sharing clips on his phone with the employees that he's managing of RuPaul's Drag Race. And one other thing that he starts doing because he's such a fan of the show is he starts saying bye Felicia to his employees that he's managing as just a fun way to say goodbye because that's something that RuPaul says. And so he wanted to start saying it too. Well, one employee gets offended by this. He's offended that RuPaul Drag Race he feels that he's being forced to watch it by his manager. He Googles what "bi Felicia" means and thinks that it's derogatory and means "bi bitch." And he ups and files a lawsuit for sexual harassment. And I took a look at this and I just thought this situation is nuts. The manager who's who's just dropping RuPaul quotes, that's nuts. The the plaintiff who decides that constitutes sexual harassment, that's nuts too. And then the attorney who's representing this person who didn't just like send a demand letter and give it a shot, but like filed this in federal court, that guy's nuts also. And I just this that sort of messiness, that kind of human experience instantly drew me to labor and employment. I think it's by far and away the most human of civil litigation, and that's what's kept me here ever since.
That's a great origin story, and that's a great anecdote. Thank you for sharing that, Ethan. That's um yeah, it's I think this is the first time that the words drag race and RuPaul have been uttered on this podcast. So they're the first time for everything. So Ethan, can you walk us through that first part of your journey, right? Obviously you went through law school. Now where in your journey did this come up? You were presumably on the defense side in this case, because it sounded like it. And so can you walk us through your journey on the defense side? What was some of the work that you did? And then later after that we'll come to your plot twist, so to speak.
Yeah, so I spent the first part of my career in big law firms, first at Womble, Dickinson, and then later at Seyfarth Shaw, doing labor and employment work. As you could guess, I pretty quickly gravitated to just doing labor and employment work and leaving the general civil lit world behind. And then in that role, I was representing companies in all sorts of employment litigation disputes, whether discrimination, harassment, retaliation, advising companies on policies, how to handle certain sticky situations, and eventually started to join a wage and hour group that was particularly prominent in Seyfarth's Atlanta office. I moved down to Atlanta and really started to work a lot closely with them, found that I had a real affinity for that type of practice. And that's where I started to develop my specialty of wage and hour collective actions, which I've continued now onto the other side of the V.
That's great. Okay, so the big question then: what prompted you to switch to cross the V?
I think when you're making a big employment change like that, it's never one thing. It's always a combination of things. But the biggest thing that I think sticks out in my mind is that as a lawyer, we're in a very high work industry, a very intense industry. You have to put in a lot of hours. You're really dedicating a good portion of your life to your work. And I think to do a really good job, you have to really kind of care about the work that you're doing. And for a long time, when I was doing the defense side, that was exactly my experience. I really kind of cared about what I was doing. I cared about my clients and representing these companies as best that I could. But then I hit a certain point in my career where I was just frankly getting a little bit more cynical about the practice of defense side employment litigation, and felt that a big part of my job was trying to deny certain people uh, compensation that maybe they shouldn't have been denied. And it just wasn't fulfilling me in the way that I think it needs to when you're going to want to do a really good job representing clients working the amount of hours that you have to work in this field. And so I looked around for ways to kind of recapture that joy and those values in my work. And I came to plaintiff's law, and it hasn't disappointed at all. I love my clients here. I love representing them to the best of my abilities, and it's really been a great fit.
Thank you for sharing that, Ethan. There's a fascinating insight in what you just said, which is that hey, the hours are going to be long no matter which side of the V you're on. And so you're going to have to meet the demanding workload that you have with those hours, and with sort of the cognitive intensity that you need to put in to deliver your best work. And the best way to do that by avoiding burnout is to make sure that your values are aligned with the work that you're doing. Essentially, if I sort of may paraphrase a little bit, is that a fair statement?
I think that's exactly right. I think that's completely fair. I mean, you see burnout throughout our industry, and at least from my perspective, that's the best way that I found to cope with the hours and to really kind of continue elevating my work in my field.
That's great. So, can you give us a couple of examples, obviously, without going into the specifics of the kind of work that you now do, and sort of maybe making it real for me and for our audience in terms of some of the fulfillment that you feel in terms of you mentioned that it hasn't disappointed at all. So, can you please share one or two examples like that?
So the majority of my work that I do now is I represent individuals who have been unfairly paid in their work, whether that's working, having to work off the clock, whether that's not being paid the correct amount of overtime, whether that's not being classified correctly as a hourly versus a salaried worker. The biggest chunk of my work is fighting for people who employers have not paid like they should have for the work that they did. And and I primarily do that through collective actions, which is the wage and hour version of a class action. It's similar to a class action, except you have to get employees to opt into your case, as opposed to a class action where folks are automatically in and then have the choice to opt out. So it's a little bit more difficult to kind of get participation in that way. But my clients, they usually start as just one or two people complaining about an employer doing a certain sort of wage practice, and then they snowball from there. And so my job, is both to represent my plaintiffs in instructing them in the law and kind of guiding them through the litigation process, and then also defending them in court, going against very sophisticated defense counsel and trying to get the best results for them as well. I think one of the big things I found switching from defendant to plaintiff side is the type of clients that you have here. On the defense side, you have very sophisticated companies, huge legal departments that have their own opinions of how cases should be run, and have lots of experience to really kind of dictate strategy and be a partner in a lot of ways, which can be good and bad. On the plaintiff side, for the most part, these are the best clients too. This is their first introduction to our legal system. And so they are coming in brand new, and they are really relying on you to tell them how the case is going, what the next steps are, and to really be their guide through this process.
Thanks for sharing that, Ethan. I want to pull out that thread a little bit. So, so it sounds to me like there's a resource imbalance almost. Like on the defense side, you have these corporations who know what they're doing. Their attorneys know what they're doing and have done this many times before. And as you mentioned, this is maybe the first time for to the entire legal system, which is interesting for some of your clients. So on the face of it, it sounds like the deck is stacked in favor of the defense. But what is one advantage that potentially your client might have that the defense might underestimate, and that probably leads to a favorable resolution for your client?
I think on the plaintiff side, you've got a nimbleness and a clarity of focus where you've got one person that's focused on, or several people that are focused on one claim, and that's the entirety of their legal world, and that's also the entirety of your relationship. You are directly corresponding with that party. On the defense side, when you're representing companies, who exactly your client is can change, what their priorities are can change. And so you're dealing with a lot of layers, a lot of moving pieces, a lot of shifting of priorities. On the plaintiff side, there's no shift of priorities. This is it. This is what they care about. In this case, they care about getting paid for the work that they've already done, and getting damages for it being unfairly underpaid. And there's not going to be any other considerations that come up. And so you really kind of get a streamlining and a focus on the plaintiff side that is the defense side you just can't have because there's just so many other stakeholders on that side.
Got it. In terms of the types of clients you have, is there a typical sort of is there an archetype? So is it like, hey, it's this kind of blue collar worker working in this sort of position, or is it like a white collar worker, or is it across the spectrum? So that's the first question. And then second is, what is the nature of the nature of the dispute across the various segments of clients that you have?
So the biggest split I'd say in terms of plaintiffs of wage and hour law is going to be if you're paid salary versus hourly. There's totally different rules for each of those. And most of the claims that you're going to see in wage and hour world are going to be hourly workers, or it's going to be saying that salary workers actually should have been hourly workers. Because hourly pay is where you can get into your overtime damages, which is really the key to a lot of wage and hour law. So majority of my work is going to be either hourly workers or it's going to be salary workers that we're saying actually should have been paid hourly. In terms of a larger archetype, I mean, the great thing about labor and employment law generally and wage and hour specifically is it really reaches across all industries. There's no industry that this doesn't touch on because all it takes is employees and payroll, and those are really all the elements you need to start seeing claims. I think beyond that, really, like kind of going back to what I said earlier with the unsophistication of the plaintiff is really the through line that I see in these cases. It reminds me of there was a book that my judge that I clerked for, Judge Mullen, insisted that I read during his clerkship. It was Franz Kafka's The Trial, and it tells this story of this character who's going through this legal system that is Kafkaesque. It keeps on building further complications. He's being told to go to different places he doesn't understand. There's rules that he doesn't understand. It seems that everyone who does understand is part of a secret organization. I often think of my plaintiffs as the person in that story where there's all these arcane rules, they don't know anything about it. You need a lawyer to guide you through this process. And so that's really kind of how I think about my plaintiffs and my approach to being their guide through the legal system.
That's great. I mean, I would presume as an outcome of that that the relationships that you build with your clients are quite strong, and I would assume that they're quite appreciative once you deliver a favorable result for them.
You hope they are. I mean, you're never gonna get that 100%. But for the most part, I think they are. I think they are satisfied by the outcomes we're able to achieve, and part of that is also just managing expectations, having regular communication with your clients to ensure that they do have some understanding of the case, some understanding of the potential results, potential recovery, and all of that, and trying to set expectations appropriately. You can't do it in every case. You don't have a plaintiff maybe that's going to be following and listening to all those conversations, but you try to do it, and I think we've had a pretty good track record of satisfied folks.
That's great. Switching gears a little bit to the role of technology and data, right? So if I think about, pretty much all of us, all our activities, whether we're salaried, whether we're, hourly, there's an electronic trail of data that sort of follows us everywhere we go. Whether it's GPS data from delivery drivers, Slack messages sent late at night or early in the morning, login timestamps, etc. So how do you and your team use technology and this sort of abundance of data that's out there to recreate the quote unquote shadow workday, and to sort of make the case that your client has been working maybe more hours than they've been paid for?
Well, I think the key kind of term that they use there is this shadow work, this work outside of the work that they were getting paid for, and it's this electronic data in a lot of ways can be a gold mine for all those things. If you're an hourly worker working on a computer, there should be timestamps showing when you're logging in, when you're logging off. If you're working in a production facility, there might be badge swipes, clocking in and out swipes. There's all sorts of companies have never tracked their employees more closely than they are doing right now, and that trend is really only going to continue. And so in wage and hour world, that's so important because at the end of the day, the claims themselves come down to that data, to that data. You kind of have to show how the off the clock work manifests itself. And that data is really kind of the key way to doing that. When you think about a more traditional employment, maybe discrimination harassment case, you've got the claims themselves, and then you've got the damages where data might provide more of a role. In this case, all of that's kind of jumbled together, figuring out damages, figuring out what the data shows, figuring out the viability of your claims. It's really in a lot of ways the same question. And so it really plays a very key role in what we do.
Makes sense. How does your approach towards technology and data and just case preparation in general differ from whether it's an individual plaintiff versus a collective action?
With an individual plaintiff, you're always just going to have a much more manageable set of data to look at. But on the flip side, you're also going to be able to think about things in a more individualized capacity. You're going to be able to think about exactly how they were interacting with one manager, whether that manager was asking them to stay late or what have you. When you're talking about a larger collective space, there's going to be a lot more amount of data to consume. You might have to bring in some help to help analyze that. And you're also going to want to think of the data on a more structural level, right? You're not at that point, you aren't talking about how one supervisor is communicating and affecting one employee. You're talking about a much more structural problem in the company. And so what you're looking for with that data is you're looking for evidence of policies and structures in place that would have caused the wage and hour issues that you're claiming in the lawsuit.
Interesting. Yeah. So individual sort of, and not anecdotal, but sort of one-off situations that maybe there's a pattern there versus a structural pattern that repeats across an entire group of employees. That makes a lot of sense.
That's exactly right.
Awesome. So now if we think about sort of, your the work that you did on the defense side versus the work that you're doing on the plaintiff side, what are some ways at a high level? Obviously, you don't have to reveal the magician's secrets, but what are some ways in which you've been able to leverage that defense side knowledge and expertise to support the work that you do today in supporting plaintiffs?
I think that there's just a built-in understanding after having spent so long on the defense side of the dynamics at play on that side of the V, kind of like what I was talking about earlier, where we get to be much more streamlined on the plaintiff side, where they're going to have a lot of different stakeholders and a lot of different maybe shifting priorities and those sort of changes, and also where with a large company, even if you have a significant collective action, there's a chance that's pretty small potatoes compared to what they're doing. I mean, when you're running trillion-dollar businesses, a case, even if it's bringing millions, it's a liability of millions of dollars it's just a decimal point. And so, I think there's a bit an understanding from my perspective of the defense side, the companies, what their perspective is, and what the defense counsel themselves might be dealing with on their side of the V. And then beyond that, I think there's also just an understanding of what priorities beyond how they best go and defend the lawsuit they could be considering, whether it's the cost to the business, whether that's the dollar amount or the time invested with its people. A lot of companies can be very concerned about the time they have to invest from their people whose jobs it isn't to litigate. Suddenly they're doing deposition prep and deposition, and that can start to affect their businesses. And so I think there's also just I just have a bit more of an understanding of the different considerations that they have throughout the litigation process.
That makes sense. You mentioned time, and let's think about time from the perspective of procedures and other such items that the defense may try to impose on the plaintiff side. So there might be paperwork, there might be procedural delays, and so since you've had some experience with running those on the other side of the V, what are some countermeasures that you typically take to sort of cut through the noise and support your client, the plaintiff, in terms of addressing those or countering those delays?
I think the biggest thing you can do from the plaintiff side is that you can be proactive about it. So when you're thinking about document dumps and that sort of thing, usually that's because there's an opening to respond to very broad, large requests with a lot of data and a lot of documents. So I think being proactive in your requests, narrowing them as much as you can is helpful. And then also proposing, for example, if you know your request is going to start involving electronically searching for certain types of communications or documents, you can propose your own ESI terms and your own ESI structure, and to try to kind of confine their search as much as possible to exactly what you're looking for. It's never going to be perfect. You don't know exactly how they're storing things or what exactly they have, so you have to leave some room. But I think as much as you can, being proactive on the front end can be really the most helpful thing that you can do.
That's good to know. Thanks for sharing that, Ethan. You mentioned document dumps, and just data is such a big part of the work that you do. And so it's hard to ignore the 800-pound gorilla in the room today, which is AI. And so to the extent that you've used technologies involving AI, what is your thought on the use of AI as opposed to, say, traditional e-discovery or other type of technologies that you've used in the past? Would love to hear your thoughts on that.
I mean, I think AI is already a great tool, and I think it's just going to become more and more important in the practice of law, whether that is in helping you mine documents for the information you need, or to analyze data sets. I was just talking with a colleague of mine the other day about how, we typically, when we get spreadsheets that have lots of pay and time data, right now we need to send that to a third party. We don't have the capacity to do the calculations necessary. But he had already started playing around with doing damage models and damage analysis with the help of AI using Excel formulas. And I've been starting to play around with that a little as well. So I think there's a not too distant future where lawyers who don't know a thing about math and didn't grow up at all in learning the basics of Excel beyond like how to sum a column are suddenly going to be able to do some pretty sophisticated analysis and with the help of AI. I mean, I think something like an Excel formula is like the perfect thing to get AI's help with. So it's got a big place in my practice already, and I think it's only going to grow.
That makes a lot of sense. One question I had, going back to the wage and hour laws and sort of the implications of those laws, is that what is the most common mistake that you see employers make, even those who are sophisticated, that exposes them to sort of massive liability that they may not perhaps intend to do, but that they're now in this situation anyway, and they have to sort of deal with it?
So there's a couple different things that we look at when we get new potential clients, and some standard questions that we ask everyone. I think one thing that, when I spot, it always encourages me to go a level deeper because it signals that there could be potential liability there, is when the employer is paying based on shift time. So if you look at a pay stub and you're just seeing 8 hours a day, 8 hours a day, 8 hours a day, 40 hours a week, that tells me what they're paying for is 9 to 5 or whatever that shift schedule is. That's what they're paying for. And that's what their payroll system has been set up to calculate. And so that can immediately start getting you to question, well, is this person really starting their day on time every single day at the start of their shift and ending it? Or are there things that are getting missed because of how their system is set up? And you can also start going a level deeper than that when it becomes to wage and hour specifically. State and local laws is where a lot of the innovation is happening. So you look at that system and you start thinking about, where are their employees located? Are they located in New York or Philadelphia? They've got some local ordinances that these could be posing bigger challenges for. And so I think that's something that I immediately would gravitate towards, and kind of some of the considerations I have when I start evaluating it on a large scale.
Makes sense. You mentioned 9 to 5, and the days where everybody sort of had 9 to 5 jobs are sort of in the past. Certainly over the last decade, maybe 2 decades, even 15 years or so. Primarily because of things such as hybrid work, post COVID especially, and then the gig economy. With all those marketplaces that exist. So, how has that affected the work that you do? Because I would imagine through the sweep of your career, you sort of saw more of the traditional perhaps in your earlier career, and now there's so much sort of hybrid work and gig work that is going on. I would imagine that filters through to the work that you do today. So just your high level thoughts on that.
Yeah, that's a big question. One response that I think of is the state and local laws that are really coming out. So the federal law, the FLSA, is pretty much set at this point. There's really no initiative or discussion, serious discussions on either side of the aisle to change federal law, and so we're stuck with what we've got, regardless of the continuing change of the workforce. The places where you can see governments trying to react and develop new regulations and new laws to compensate for the changing workforce and the changing demands of companies is at that state and local level. One law that comes to mind that's becoming more and more popular is something that's called predictive scheduling or fair work week laws. And those are now, there's a couple major cities that have them. I think Oregon might be the only statewide one of these laws. And what they say is they basically say, in certain industries, particularly retail and hospitality, what you have to do is you have to tell your employees usually 10 or 14 days in advance, this is what your schedule is going to be. And if you change it, you have to give them the right of first refusal. Maybe you have to pay them a certain amount, depending on how much you're going to change. That varies quite a bit by the laws. But that's one way that state and local governments are starting to kind of try to fight back and regulate and create laws that are reflective of our modern workplace. A spot where the laws I think are falling short and where maybe more creative litigation has to come up is something like off the clock or outside of work communication, right? It used to be that there were only certain jobs where you would ever get a call when you were off your shift for the day, and now it's practically every jobs that you wouldn't think of at all. You have a manager calling an employee at, hours after their shift ended, checking up on this or that, or asking some questions about something that happened or what have you. And that's become just a reality that we live in. There's other countries that have passed laws to try to combat that, about, the right to basically turn your phone off when you leave for the day. That hasn't happened here, and that's not going to happen here. And so I think on the plaintiff side, we have to start thinking about more creative ways to litigate that and to get courts to realize that this is work, this is working time. To the extent that it's been litigated at this point, courts try to use a more traditional, like, are you working as the employer, controlling your what you can do during this time, or are you just off the clock? And this is something different. This is something in the middle. This is something where, yeah, you can run errands and run groceries, which is kind of a common thing that courts will say in this analysis. But you have to have your phone on you. You have to be able to answer probably within a certain amount of time when your supervisor calls you or sends you an email. And so what is that? What sort of work are you doing? Are you really only working, and should you only be compensated for the 2 minutes that it takes to respond to your text? Or is there a greater amount of responsibility that your employer's putting on you that you should be compensated for? So, I think there's these sort of questions that are coming up more and more in modern workplaces. Federal laws aren't adapting to them. State and local laws are to a certain extent, but I think it's also on the plaintiff employment lawyers and plaintiff wage and hour lawyers to start pushing new creative ideas of how to approach work and compensation, particularly now that the Supreme Court has really kind of done away with the highest level of deference and administrative deference, when that came out, it was seen as a big win for employers and for defense side work. I don't think that necessarily has to be the case. I think there's a lot of defense side, employer side, really friendly administrative regulations out there that haven't been updated in a very long time, that don't make a lot of sense in our modern workplace and are ripe to be challenged.
Fascinating. Thank you for sharing all of that, Ethan. As you were sharing that, I was wondering, and please let me know if this is true or not. Does this spillover happen more in sort of knowledge slash white collar work, or do you see it also in hourly? Like, let's say I'm an Amazon delivery driver or something. Do you see a lot of that in sort of hourly work, or is it more, hey, maybe I'm working at a desk on something? What's your experience been?
So I think it happens in both. I think it's probably a little bit more in the knowledge white collar work, but you also can see it in retail and in hospitality as well, that might be considered more of a blue collar workforce. You see more and more that managers are getting phone numbers from all their employees, and expecting them to respond to texts and calls even when they aren't at the workplace and aren't on call.
Interesting. Well, Ethan, this has been a great conversation. Just a couple of quick guidance-related questions to wrap us up here. One is, if I'm, an hourly worker or a salaried worker, and I feel like there's been, maybe I'm not being treated or being compensated fairly for the work that I'm doing, and this is before I even reach out to someone like you or someone like your firm. What guidance would you have for somebody sort of in that stage, before they reach out?
The most important resources you have at your disposal are your pay and your time records. That is going to tell the story of how you're getting paid and the work that you're doing, or at least that's getting tracked by the company. So I think that if you're having these concerns, the number one thing you can do is go to your employer, or go on to whatever, more and more there's apps and portals that are going to have all this information if you look for it, and look and see if you can figure out, how are you getting paid, where, what are all the different categories of payment. You can get really complicated with just a basic pay stub. And if you can try to find your time records too, look at those and compare those to what you feel like you've been working. Is it only registering 9 to 5 when you know you were working more than that? Is it showing that you're clocking in at one time, clocking out at another time, and then when you add it all up, that's not corresponding to your pay stub? So I think if you're having those concerns, doing as much research into your own pay and time records before reaching out can only be helpful.
Makes sense. Taking it back to the beginning of our conversation, and crossing the V and all of that, Ethan. So, if I'm a younger attorney or an earlier career attorney who's looking to decide which side of the V to be on, specifically in wage and hour, or more broadly labor and employment law, A, how do I make that decision? And B, when or how should I decide if I too want to cross the V?
I think that the most important thing that you can be when you're in that sort of position is to be curious, and always be thinking about, yeah, I'm in this role right now. This is the sort of work that I'm doing. This is the sort of experience that I'm gaining. And always be thinking about, what else could I be doing with this work and experience? Am I happy in this role? Should I be going to the other side? Should I be going in house or to government? There's so many different things you could do, both with wage and hour, but with a labor and employment experience writ large. And the best place to get those questions answered are, find labor and employment organizations where you can meet in person with people. This is something that just can't be done. As much as I love technology, this is something that just can't be duplicated online. So what I would suggest is, be curious and find in-person opportunities with organizations that are specializing in labor and employment law. There's state bars, there's local bars, there's national organizations like the ABA that all put on different sort of sub events like that, where you can really kind of meet and speak with, plaintiff side lawyers, defense side lawyers, company counsel, government attorneys, and that's really by far and away the best way to get a better understanding of what makes the most sense for you to do in your career, is just go out and be curious and talk to as many people as you can.
Great words of advice. Thanks for sharing that, Ethan. Final question for you. Is there a question that I should have asked you, but I didn't?
Now that I'm on this side, I wish that I had more of an opportunity to talk with in-house counsels themselves, because you're typically only talking with the defense counsel, and you don't have an opportunity to talk with the company counsel themselves. And so I think one question that I could have been asked would have been, what advice would I have for in-house counsel after they are faced with a FLSA wage and hour collective action lawsuit? What tips would I have based on my perspective from both sides? And for them, what I'd say the most important thing is understanding that wage and hour is a very niche part of labor and employment work. And so if what you're doing is you're going to your typical labor and employment general counsel and asking to defend you on this, you are immediately going to be behind the eight ball. And I saw it on the defense side too, with plaintiffs that were general employment lawyers bringing FLSA collective actions. It's very niche. It has its own language. It changes a lot by jurisdiction. If you aren't doing it every day, then you are really going to be kind of at a disadvantage in litigation. And so I think, from the plaintiff side in particular, we really appreciate, and for the vast majority of time, we do get defense counsel on the other side that you just look at their bio and it just says FLSA, wage and hour, state and local. Like when they're in wage and hour world, you can tell immediately. And when they aren't in wage and hour world, you can also tell that immediately. And so what I'd say to corporate counsel is when you're faced with something like this, make sure you aren't just going to a generalist. Make sure you're going to someone who specializes this and knows what they're doing, because they're going to help you develop strategies. They're going to help you figure out, should you resolve this? Should you fight this? What are the economics of each in a way that a more general employment lawyer is just not going to be able to do. And you can really see it. At Seyfarth, I was part of a specialist wage and hour team, so I didn't see it as much. Now that I'm this side and I compare the sort of advice and the sort of strategies we would have done there and see what some other folks do now on this side of the V, I think there's some chances for improvement in their counseling. So that's what I'd say to them.
Fantastic. Well, Ethan, on that insightful note, this has been a wonderful conversation. I learned a lot, and I'm sure our audience did as well. So thank you so much for your time. I really appreciate it.
Thank you for having me. This was a lot of fun. Happy to get on the Zoom and talk with you for a while.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.